But what nobody says about none of that, I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit.
If he thinks we can't do something, you're going to look at this judge and think I can't do something, young man. You're going to learn a big lesson.
Court calls the case of the people versus Marquisi Hankey.
Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, except one.
All right, it's your motion.
They probably motion to protect previous PCC hearing. My client's bond vote from privileges from the jail suspended due to allegations that he cut off his tether and contacted the complainant. Following that particular bond hearing, I instructed my client to not contact the complainant witness, period, in the jail. I also instructed my client that if allowed to be back on bond, we would ask the court to hopefully just reinstate his original bond. Tether, I would know judge that he has no prior criminal, well, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Obviously, people address this. Some of the language that was used in our conversations, I don't have phone conversations myself, but I will admit, Judge, that it seems that my client had contacted the complainant even after his bond. And so I say this, Judge, again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. He is.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something it means. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier refund that he was able to post to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So Judge, I am asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. And so at the very least, the restriction on his phone privileges to contact family.
All right. Well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order.
I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on emotion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, There's not shit in this world that's gonna stop me from talking to you, man. Nothing in this world's stopping me from you. I don't hook up what nobody says about none of that. I'm gonna be calling until my court date. They're not gonna do shit. At the end of the day, they can't do shit. I'm gonna talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing. And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim on other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel?
I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but yeah, it's close, but I did pretty good. I said it okay, right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. He is pregnant by my child. I can't say that I'm not in here for nothing. You obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. Again, please show mercy. Please. That's all that matters.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir.
Move forward with the,
Is all discovery complete?
and I would ask if possible, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge Perry.
And Your Honor, I did want to make it clear where I did contact the jail yesterday, and they have blocked both of victims' new numbers and old numbers, so there should not be any more
calls coming through. All right. Thank you.
Thank you very much, Judge.
Thank you, Your Honor.
Where are we on this, folks? Because,
I filed the proper paperwork.
well, I don't know that you did. Okay, so here's the problem. I don't think that I have subject matter jurisdiction over the case, and let me just explain it so everybody knows what I'm talking about. In order for the court to obtain subject matter jurisdiction over the case, I have to have a proper notice to quit. When we were here, and I kind of explained it the last time that we were here. When we were here the last time, you were indicating to me that you gave them a notice to quit on the case. I didn't have it in my file. And I kept asking you, well, when did you serve it on them? Because I think they were saying they hadn't gotten a notice to quit. So I said that I had to have the one that has the proof of service on it. And I adjourned it out to give you an opportunity to correct that. Because if it had been served, it was. So you filed with the court a notice to quit. And importantly, on the notice to quit that you filed, it says that they had to move by February 28th, 2025. and that you served it on them March, as I'm looking at it here, March 10th, 2025, is what it looks like to me. And it says it's served by first class mail. Assuming this document to be true, I don't have jurisdiction over the case. And in fact, I'll just say this, this document, if that's the March 10th date, it can't be, because you can't tell someone they have to move by the 28th of February and not give them notice that they have to move until March 10th. The only way that this notice, as it is signed by you, can make sense is if it were served on them on March 10th, they would have until April 11th or April 10th in which to move. So when I look at the face of the documents, this notice is invalid. With the dates that are on here, it can't be true.
I additionally went with that notice to quit, had this file, had the police officer do it the correct way, because that's what I was told to do from this court. The notice to quit. You said that I had to show proper paperwork of me serving them the correct way. So the first time I served them was January.
And we went through this the last time. You gave me, and when you were talking about the police officer serving, that's the service of the summons and complaint. That I don't necessarily, as I'm looking at it, have a problem with, that they would have received a summons and complaint from the court. They would have had an officer or somebody show up to serve that. That I'm not having the issue with, and that's what I was trying to explain at the last hearing. Because the document you handed me, that you were talking about that. What I told you was the notice to quit. I didn't have a copy of when it was served on them. Gave you the opportunity, you said you did, I gave you the opportunity to correct it. I'm not sure what date it was received, but the document that we received that was received by the court is a notice to quit to recover possession of the property. I will say two things about that. First of all, it doesn't match. The top portion of that notice to quit does not match what I have in the file, which leads me to believe that it's not the document that was served on them, if it was served. Then even aside from all of that, and so in reality, it's not a valid notice to quit. But even aside from all of that, if I were to say, give me the benefit of the doubt, I'll just look at it, I'll take the dates. You can't give somebody a 30-day notice, tell them to move by February 28th, and not tell them until March 10th.
Your Honor, I think it's a misunderstanding. I served them a notice to quit on February 28th because I'm following all the court steps. She said, first of all, you have to file a notice to quit yourself. And then if they don't move, you come to court, you file this paperwork, and then you come to court. So I served them, correct?
No, you don't get the question. What are you saying? You have to give me a proper service here. And I don't have it. I don't know what that notice to quit. You keep saying that you gave them one. I don't know what it says. Because your two notices to quit are different. The one that you gave me just recently is different than what was attached. The top portion is different than what was attached to the complaint that was filed. One is typed, the other is handwritten. It says move by the 28th, but the way it works on a 30-day, I tell you, if I were to give somebody right now
a 30-day notice today, the 18th. I would say if I serve it on somebody today,
Your Honor, I served it on January.
just don't interrupt me. April 18th, I would give them until May 18th to move.
Correct.
Your notice, on the other hand, says you have to move by February 28th, but I don't tell you that until March 10th.
That's the second.
Can't work that
That's
way.
the second notice, Your Honor. The first notice, they told me to serve it. You have to have a 30-day notice to quit. I served them the 30-day notice to quit January the 28th. So they had till February the 28th to move.
Then why don't I have a proof of service that it was given to them on January 28th? I don't have that. I told you to come back, and usually I wouldn't do it. Usually I would have kicked this case the last time. You kept telling me that you had it. I see a notice. I don't have the proof of service on the notice to quit. I gave you an opportunity to correct. What I got
Your Honor,
is an impossibility.
Your Honor, what you got is what the court told me to do. They said file a 30-day.
You're not going to blame the court. The court didn't tell you to do this, because I think this is a falsified document if you want to really get down to it. Because the notice to quit that I have in the file is typed. The notice to quit that you gave me is handwritten. It can't be the same. I don't want to accuse you of providing false documents to the court, but that's certainly what it looks like. And secondly, the date, as I indicated, and I will say, you can smile at me all you want, but I'm going to tell you right now, if I think you filed a false document, you're going to get a show cause, and you're not going to like what happens. Am I clear? The document that you gave me is a factual impossibility. You cannot tell somebody to move February 28th and serve them on March 10th. It can't happen that way, because you're telling them to move after the time that you told them to move. You can't do it. That's what's in this file. So giving you an opportunity to do that, I've given you an opportunity to correct it. You failed to correct it. I will state on the record, I think you've provided to the court a false document. This court lacks subject matter jurisdiction pursuant to the cases decided by Michigan Supreme Court. I don't have jurisdiction over this case. The only thing that I can do is dismiss it. This case is dismissed for lack of subject matter jurisdiction. Thank you. What'd you say? Ma'am, you better bring her back here. Bring her back here, Alan.
Your Honor,
Yeah, go back there someplace, because when she comes back in here, it is gonna be a mess.
Okay.
Don't go out into the hall yet. Call security down. I don't know, someone say who wants to go next. But what? They're coming down. I'll wait. Come back here. Everybody doesn't have to wait for.
Sorry to interrupt. Your Honor, are we allowed to leave you?
I'm not clear what's going on out there.
Okay.
All right. So if you just sit tight, he was trying to explain something to me. I was trying to finish up that case, and do we know?
We do now, sorry. Would you like me to?
Well, no, because I don't know what's going on out there. All right, you two, since you're the one that caused my troubles. No, I'm kidding. You two sit right there until we tell you to leave. All right? So that'd be simple. The rest of the people here are probably for my next block, which I'm just gonna let you know right now is gonna be a bit delayed, but I will get it called. And I'm gonna step off the bench and try to figure out exactly what's going on. Okay? Thank you, folks. Court's gonna stand in recess.
14A District Court for County of Washington, State of Michigan is now back in session. The Honorable
You may be seated. Okay, you two. She's out of the building and clear.
you can go. All right? Just give us a heads up when you're gonna grace my doorstep again, all right? You guys take care. Have a great weekend. Almost don't want to call anymore. I guess I will. It's just that. Sile Farms versus Teresa Tomasi.
Brianna Kingsley for the plaintiff.
Tomasi, we saw you for a minute. There we go.
Okay.
Okay. I had the last time we were here, 344320 owing.
Yeah.
And your SER was declined. Says that you were working with SOS.
Yeah.
Okay. You have any news on that?
Well, I've called for 3 days in a row to the lawyer's office for them to mail the paperwork over, and they haven't emailed it over or called me back.
So she applied for rental assistance through Hawk. All the documents already been provided to Hawk.
Talk.
To Hawk.
Do you mind
they,
if
they were provided via me on a text on an email yesterday after 3 days of them not responding. It was not given by the lawyer to Hawk. It was done by me alone. And it was so for the last 3 days, and they still haven't returned my phone call. So sitting here 3 days ago, you guys didn't return my phone call of whether or not you emailed it. And I don't even think that they replied to my the people in the neighborhood here. Long story short, SOS has granted me $3,000 for the rent. Thankfully that I gave them the paperwork for yesterday.
Ma'am.
Yeah.
Do you mind if my court liaison officer provides information to the court regarding the status of where things are?
Yeah.
Do you have a problem with that?
Okay.
Okay. Amy?
Your Honor, working with Alicia, there's a co-payment, so that portion above the 3,000 needs to be satisfied first before.
They'd pay that. Okay. All right. Did you hear that, ma'am?
Yeah, I've got the money order here. Yeah, I've got the award letter from SOS this morning for the 3,000. I've got the money order here for the 442.
Okay, why don't you pay that to the landlord?
Okay.
And then
Okay.
let me adjourn it out a week and see exactly where we are on everything. Okay?
Yeah, and I'll vouch for the water. My poor neighbor hasn't, he literally would wash the laundry once a week because his bills was $300. So it is not just that lady. FYI. So
I'm just
not
gonna
like either, but my poor
okay,
neighbor
well,
literally doesn't do his laundry every 3 weeks. So, all right. Thank you.
All right, thank you for sharing. April 25th,
Yeah.
3 p.m.
25, 3 p.m.
Thank you, Judge.
Thank you. I'm gonna get up and walk out. I'm just gonna leave. If I do, folks, you'll just have to understand, and then I'll come back. I'm just trying to make it through another day, okay? Court calls the case, Sile Farms versus Paul Dest.
Brianna Kingsley for the plaintiff.
Paul Dest?
And I believe Leah.
Oh,
Dest
I'm
is-
sorry, and Lee Dest and Paul Dest. Twice. Okay. Okay, who do I have here? Bye. Yes, ma'am. All right. Your name? Paul. All right.
So I have an update for you on this one. They've submitted the payment. We're just waiting for the checks to clear. So could we just adjourn this 1 week and
Oh, great. That's all right with you folks?
One week, I'm a little confused about the checks to clear.
we're waiting for the checks to clear?
How long do they take?
When did you give them the check?
They submitted 2. They
Gave
submitted
them one
one
today, gave them one
earlier this week.
Wednesday. Sometimes they take a month to clear, so I'm just curious. Yeah.
Are you good with 1
Yeah,
week?
it depends on how quickly they get to the main office. They've already been both overnight. The one should have already appeared at the main office and.
They had-
check with them.
Okay, so they go here, then they go to the main office, and the main
Well,
office
it's
is
just-
the part.
The type of check that it is, it has to go to the main office to be posted. That's what it is.
I'm just gonna have to take more time off work to come back.
No, just
That's why we gotta come back.
calm down. Calm down. I'll work through that part. Okay? Just tell me what your issue is. I'll do my best to work.
All right.
Okay? You need to take your hands out of your pockets because that gets him upset. And then that whole thing.
All right.
Okay? We don't want that. All right. Here's what I'm gonna do. I'm gonna adjourn it out a week, the 25th, 2025 at 3 p.m. I really don't necessarily need you here. Okay, one of the two of you can appear via Zoom.
So,
Okay. And it's just a matter of the checks clear. That's all we're looking at.
so if it's not clear in a week, then where are we at? I just would like to know, I mean, it's just a question.
Well, that's a bit difficult to answer, only because if it doesn't clear because the bank is kind of they've got it, but on a hold, that's one thing. If it doesn't clear because the funds aren't there, that's a whole different thing.
The funds are there.
Okay, I know, sir. What do you want me to do? What do you want me to
I
do?
just want to answer what a reasonable amount of time is to cash a check.
I don't know, because it's different things. If you were listening, what they just explained is it came into their office because of the type of check it is, they have to send it to the main office. I'm not in charge of those folks as to when they deposit.
Right.
The best that I can do is set it out a week. You've told me about your work issue. I will allow either one of you to appear via Zoom so that we can just get it straight. That's the best I can do.
That's fine.
April 25th, 3 p.m. Thank you.
Thank you, Judge.
Fill out a Zoom form so that I don't have to go through this, please.
Thank you, Judge.
Yeah.